year, this is the slides. So this is what Ryan will be sharing with us on the screen. The one below that, the 55 employment laws, is something he's going to refer to on a number of occasions, and that is a very massive document, but one that you'll want to keep near and dear to you when you get back to really synthesizing all of this and putting it all together, because that has information on, true to its title, 55 new employment laws and regulations that we need to be aware of for 2024. So those are the two different documents that you have there and how to access them. So, and now this is, I've said this before and I'm going to say it again, but this is always one of my favorite times of moments in WeLu, when I get to introduce the Light Gabler session, because Light Gabler never comes to us with a title like employment law update. There's always something a little bit more creative with that. So we always appreciate that. Last year was New Year's State of Mind, which I'm going to go out on a limb here. I'm thinking references a Billy Joel song from the 70s, or plays off of that. This year, where it's the most wonderful time of the year, which references an Andy Williams song from the 60s, I think it is, maybe the 50s. So I'm guessing if we come back and in maybe 10 years from now, we're going to be going back to the 1920s, and it's going to be a Jitterbug reference or something like that. But it is my pleasure to bring back to WeLu Ryan Hawes. Ryan practices in the areas of employment law, advice, and counsel and employment litigation. He's got an amazing background that goes beyond just his work as an attorney, but a background in social work and legal experience with employment and family law. And his focus is really on resolution of employment disputes, workplace disputes, defending client interests, providing guidance to employers on complying with legal standards, but always with an eye toward business productivity and employee morale. So it kind of fits the overall theme of what we're really working on here today. Ryan spends a lot of time working with the Light Gabler clients on training, on preventative action, on handbooks, leaves of absence, workplace privacy, internal investigations, you name it. Pretty much all of the hot button items is what Ryan works on a day-to-day basis. For those of us who spend a lot of our time in the Ventura County area, such as myself, you may know Ryan from being around town and the many activities that he's involved with locally in the Ventura County area. Always a pleasure to welcome Ryan and of course his colleagues that have graced our WeLus in the past, John Light and Karen Gabler. But today we're going to get to hear from Ryan. So Ryan, thank you so much for being part of WeLu today. Really appreciate it. I'll turn it over to you.
Great, Bill. Can you hear me?
Yep, sounding good.
Okay, great. Good morning, everyone. It's great to be here with you today. I put it on gallery view for a second and I saw so many bright, smiling, shining faces out there. Well, I'm going to wipe those smiles off your face in about 5 minutes flat. Put me on the timer. I'm joking, but in all honesty, I have very little good news to give you today. I was thinking back and I thought to myself, well, it seems like I was just here 2 weeks ago doing the 2023 update. And where did the time go? Right? Another year older, right? A new one just begun. Go back to the Christmas songs that we're hearing. And I do want to thank at the very outset, I want to thank Employers Group for setting this up, for making this sort of information accessible to all of us here today so that we can get prepared for the latest and worst from our state and from our federal government for 2024. I could feel the energy in the room just looking around. You had some great topics ahead of time. That's fantastic. So let's move forward. Hopefully each of you has accessed the handout. We're going to be working through that as well as through the PowerPoint presentation, kind of hand in hand. So hopefully if you haven't already, you'll pull it up. What you'll see there, and many of you come to these presentations annually, so you know how this process works. But for those who don't, you'll see 55 topics. Normally we do 50 topics, but with inflation this year, we did a 3.5% increase, right? A COLA increase on our packet. So there you go, you get more new laws. Happy you, right? Now you're already smiling. I see a couple of you shaking your heads already. We are 2 minutes into this program. Stick with me, people. Stick with me. You're going to see in there a table of contents. This is loosely organized by topic. We also put it alphabetically. Our intent is that you'll be able to go back and navigate later easily to any topic that's of particular interest to you. We also added a legend this year. We're trying to demystify all of the employment law acronym soup that we get all the time, PDLs and CFRAs and FEMLAs and all those different terms. So hopefully that helps you as you're trying to navigate through your HR practice. Now, as you go through the packet later, as you're doing your individual review of all of this content, make sure that you pay particular attention to the practice tips. It's in those areas we've given you some general best practices. Now, as a pointer, we draft this to be overly conservative. I had one client the other day tell me it was grossly conservative, is what they said to me. It made me chuckle a little bit. I said to myself, well, what do you want to do? You want to risk a litigation? And maybe they did. And risk management is up to any company. And I never try and tell people how they should manage their risk. I give them advice, they pick and they choose. And then they get to deal with the consequence. I think of the law. Let me give you a great example. We have the 5-hour rule in meal periods. We all know about this. You have to start your meal period before you complete 5 hours of work. That is a drop dead. 501 is a technical violation of the law. I call those the cliff edges of employment law. But when I look at policies, I see almost every policy saying, we're going to schedule you to start your meal period at the 5th hour. And I say, why not walk back from that cliff edge? Start your meal at 4 hours, 4.5 hours, something to give yourself a little flexibility. If any of you are hikers like me and you do any active hiking, you know you never hike on the cliff edge because you might fall off and die. So our intent in drafting this for you is to be a little bit more conservative, because although it's good for my business when you're in litigation, I am not a profit center for your company. And if you're with me, the meter is running. Now, I'm fun and I like to do fun things and we could hang out, but it's going to be at a cost. So make sure you're thinking about that as we go through the presentation today. A couple other points, if you have questions, throw them in the chat. Bill's going to be monitoring the chat. But if your question starts with, I have an employee that, or I have a friend that has an employee that, or hypothetically, if I were to have an employee that, those are topics better addressed with your individual counsel. But for general questions, happy to address those. And Bill, feel free to interrupt me at any point. Enough with the boring stuff. Let's jump right into something exciting. Let's talk about our disclaimer, which you'll see at the very top of our packet. It says this information is general in nature only. It's not intended to be a substitute for legal advice. The value in your employment counsel is when you take the law, you take your specific facts, you apply to a lot of those facts, you come up with a good result. So make sure you're reaching out to your employment counsel. Hopefully it's us, but it might be somebody else. Either way, if you have questions, we're happy to address them. With that, let's jump right in, fasten those seatbelts. Let's get started. But no, like I said, I mostly have bad news. So again, people shaking their head already. It's not me, people. I didn't do it. I'm just the messenger. Okay, let's jump right to number one here. Number one says, this is just a summary of the legislative session. So you know what happened in this past legislative session. We have a supermajority Democratic legislature. And during the last legislative session, they sent 1,046 bills to the governor. 2023, in fact, was the most active year in legislation we've had in about 2 decades. Of those bills, 890 were signed, rubber stamped by Governor Newsom. That's an 85% signing rate. I had a client so frustrated the other day. She said to me, I'm going to fly to Sacramento. I'm going to steal all the governor's pens. That way you can't sign any new bills into law. Now, she was joking, but it sort of makes sense. And historically, he's right in line with what he's done in years past, where he signed between 84 and 88% of all the bills that come in front of him. He did veto a few, and there were a few surprising ones. We'll talk about those later because they're likely to come back. I call it the boomerang effect. But he was right in line with what he's done in years past, about 14 to 15% veto rate. 10% of the bills that he signed dealt with labor and employment topics, and that's where we'll focus today. We're going to be focusing on the broadest and highest level application of those laws. So if you say, well, gee, Ryan, you didn't cover some sliver bill that applies to my specific industry or some local nuanced rule, that's because we just don't have time, right? If we were to do that, we could be here for months at a time. But feel free, again, to reach out to your counsel of record. We'll talk about those. Most of the bills in this packet, unless otherwise noted, go into effect January 1, 2024. There were 2 urgency measures. We'll talk about those. Those are individually in your packet if you're following along, numbers 26 and 47. So you can flag those later. And all of these are generally California laws, except where noted. We do cover some federal bills as well. 2 points to keep in mind. We're talking about mostly California or federal law here. And so there's a lot of local rules that might apply to your organization. If you're in California, you're subject to federal rules, state rules, local rules, and administrative related rules. It's a lot of sets of rules. And as a general practice point, whatever rule is most beneficial to the employee, right? Not the employer, to the employee is the rule that's going to govern. And a lot of times that'll be local rules. So make sure you're double checking your local rules. Also, be wary what you find on the internet. I told this at the last event, but I had a client call me up and say, hey, I saw a law that says I can check work comp history for my applicants. And I said, no, absolutely not. That's a huge no-no. And they said, no, I have the law. I've seen it. I can do it. Will you just ping your group? And I said, fine. We got 20 plus employment attorneys, all seasoned attorneys. And so I ping the group, hey, this is a no for me, but what do you think? And every single one of them comes back, this is an absolute no-no. So I go back to the client and I say, why don't you send me the law you're looking at? They sent it to me. They pulled it off the internet. It's from Queensland, Australia. Queensland, Australia. They do things a little bit differently down under, right? So if it's too good to be true, don't put another shrimp on the Barbie, right? Let's just be a little bit more cautious with our internet searches. Jumping right into number 2, we have agricultural overtime. This is a reminder. This is number 2 in our packet if you're following it. It's AB 1066 from Governor Brown's era. This is almost over. What it does is it phased in overtime for agricultural workers, wage order 14. Doesn't apply to you, take a quick nap. 26 or more employees, larger employers, you're already at 8 and 40 as far as your daily and weekly overtime requirements. Smaller employers, you got 1 more year of reprieve, and then you're going to have to comply like everyone else. The intent of this bill is to move everybody back to an 840 standard. The meal periods now apply to most agricultural workers, except for a few limited exceptions. So pay particular attention to this. There was also a modified wage order 14 a couple years back, so make sure you have that up if it applies to you. Arbitration. Now I say this is an update, right? We all remember AB 51. This was 2019. This was the bill that purported to say you cannot have mandatory arbitration of any FEHA or labor code claims. Big deal. Big deal. Tons of litigation back and forth since this bill came out. It was initially stalled out at the district court level. It went up to the federal court level. That has ping-ponged back and forth multiple times until we had this recent decision from our United States Supreme Court this last year, Viking River, which didn't necessarily deal with AB 51, but had tie-ins, right? It dealt with individual PAGA and arbitrating those sorts of claims. Right after that Viking River case comes out, the Ninth Circuit, which was reviewing the AB 51 case, withdrew its former opinion and said, we got to reconsider this. Most recently and most applicable to all of you, and you'll probably hear this a little bit later, but in February of this year, the Ninth Circuit reversed itself. It did a full 180-degree reverse course. It said, it didn't say this, but in essence, it said, we got it totally wrong. It affirmed that the FAA, the Federal Arbitration Act, this is near legend, right, preempts AB 51 in its entirety. That means there's still an injunction in place against the enforcement of AB 51 in its entirety. What does that mean? It means mandatory arbitration is advisable and you should be doing it for your new hires. Hopefully all of you are doing arbitration. I tell employers in California, nothing is bulletproof, but the 2 things you can do to mitigate risk, have arbitration, have EPLI, Employment Practices Liability Insurance, and ask your carrier, ask your broker about the wage and hour rider for defense fee coverage, right? EPLI doesn't cover wage and hour stuff, but you may be able to get a little rider to cover defense costs. So the litigation's ongoing. So a couple of key points here when you're looking at your arbitration agreement today, and hopefully everyone has a little note. I see a couple people with notes out. Take down action items today. Number 1 is if you haven't updated your arbitration agreement this year, make sure you do it ASAP. We want to say we modified our agreement 3 times last year based on cases that came out. A lot of significant stuff happening in this arena, mostly because federal law loves it, state law hates it. And so these 2 are battling all the time. If you have in there that you can have arbitration of pre-dispute sexual harassment or assault claims, take it out. That was HR 445 from last year, federal law. Also, for those of you who are very risk averse, and I have some of those clients, the litigation is not final. It's possible that this could go up to the Supreme Court, for example, and it could ping pong. It could go back the other way, right? It could go back to AB 51, or part of it is valid. So be thinking about that and assess your level of risk. Okay, another arbitration case. This is mostly for any attorneys that might be here. This is AB 365. If you have the packet out, it's number 4 in our packet. It modifies the Civil Code of Procedure. And what it says is there's no longer an automatic stay of an order dismissing or denying a motion to compel arbitration. This is exactly opposite of what the law has been, and exactly opposite of what the federal courts hold. There's a recent case here from the federal court, from our US Supreme Court, that says we do just the opposite. We do have an automatic stay in the federal courts. Coinbase, for any of you Bitcoin people out there, I hear it's pumping. I don't know, but I hear it's pumping. Wait and see what the California courts do next. This is, again, a disparity between our state and federal laws that continue to battle it out. State hates arbitration. Feds tend to love arbitration. Background checks, fair chance regulations. Now, this is just an update for you. All of us know that over the last couple of years, there's been a significant narrowing of how you can use criminal history in your hiring processes, right? Just to mention a few bills, a couple of years back, we had AB 809. Thankfully, that bill didn't pass, but it sought to get rid of all criminal background checks unless required by law. Didn't pass. Last year, we had SB 731. What it said is people can seal their criminal histories after a number of years, so long as they completed their term of incarceration, probation, parole, and supervision, and they didn't get a new felony within 4 years. They could seal it, meaning you don't get access to it as an employer. Similarly, they had SB 1262. This was also last year, which said you can't use people's social security and date of birth to look at the court system's online records for criminal histories. Stemmed from a case from 2021, All of Us or None versus Hamrick, if you remember that case. And then, of course, we had the ban the box rules, AB 1008, 2018. Most broadly, in the broadest sense possible, this is what gave us the Fair Chance Act on a state level. And what it says is you have 5 or more employees, you cannot ask about criminal history unless, right, you've given a contingent offer of employment and you've gone through the proper notice procedures. Now, there are some narrow exceptions. We're not going to get into those today. But broadly, that's what that law said. And then it said, even if you do that, even if you do it after a conditional offer of employment, if something bad comes back and you want to revoke the offer, you've got to go through a process. You've got to go through what they call an individualized reassessment process, right? You've got to consider a bunch of stuff. We'll talk about it in a minute. But then you also have to notify the applicant in writing that you're intending to revoke. You got to give them notice of the qualifying criminal history, the criminal event that's causing this. You have to give them a copy of the actual report you reviewed. Then you have to give them an opportunity to respond. Now, if they respond, then you have to consider that information. And if you still say no way, no how, we're not going to hire you based on your criminal history, then we have to give them a letter, a final letter that says we're not hiring you based on your criminal history. And then they take that letter and they go right to a plaintiff attorney, puts on green dollar bill colored glasses, right? And he brings a lawsuit. This is what the law requires of you. Also, be sure to check your local rules. Areas like LA, San Francisco, they have their own fair chance ordinances that are stricter than the state rules. Okay, here now, what are we talking about? We're talking about state rule modifications. If you're wondering where you find these, look in the packet, we gave you the link. Or if you don't want to do that, just go to Google, type in CRD, which is Civil Rights Department, Fair Chance Regulations, and that'll pull this right up. But they're effective October 1, so these are in play and live now. What do? They modify or ban the box rules generally. And there's 5 key things I want to give you, and it's much broader than this. This could be an entire program in and of itself, but let me give you 5 things to take away. We got the broader definition of employer. It used to be that employer was just the actual employer. Now it's broader than that. It is a direct or a joint employer. It is any entity that evaluates an applicant's criminal history. It is also a staffing agency. So essentially, these rules say an employer can't hire a third party to circumvent the FCA. There are broader definitions of what is an applicant. It's not just applicants anymore, but it's also employees that are applying for a new position, or, and I want to read this to you, who are subject to review after a change in management, ownership, practice, or policy. So again, broader definition of who is covered by the FCA. Broader prohibitions against advertising and recruiting missteps. I think some employers got a little too creative. The state didn't like that. And so they came out and they said, you can't have anything in your application that says you won't consider somebody because of their criminal history. Now, local rule note here. San Francisco and LA both have statements in their Fair Chance Act that goes a step further. It says you have to put an affirmative statement that you will consider people with criminal history. So again, check your local rules. Prohibitions against using volunteered information. So after somebody tells you they have a criminal history that's problematic, you got to unring that bell. You got to unhear what you just heard. I don't know how you do that, but it's broader than that as well. It also talks about anything that you considered from an external source. So I'm thinking internet searches here. Again, people getting a little too creative, a little too loose with the rules. They expanded the individualized assessment criteria. We've had historically 3 basic criteria to consider. They are the nature and gravity of the offense or conduct. That's number 1. Number 2 is the time passed since the offense occurred. And number 3 is how tied into the job is the particular criminal history. Now, what these modifications did is they expanded each of those categories to give you laundry lists of potential subfactors you might want to consider. So be sure you're taking a look at that and check your local rules, right? You're going to hear that as a regular recurring theme throughout the day. We got to check our local rules. All right, bathrooms, potty talk, all right? Let's talk about bathrooms. Does your business have a private bathroom? Is it all gender? Do you need to have a bathroom that's all gender? Well, this comes from a law from a few years back, AB 1732, that said all public businesses, right, where there's access by the public, who has a single user facility has to have it designated as all gender. And we joked about the signage at the time. I saw one with T-Rex. I saw all kind of triangles and interesting things people were coming up with. But I told every employer I talked with, just put up a sign that says restroom, right? Simple, restroom, easy enough. But we've all gone into public facilities with single user bathrooms that don't have up the right signage. So this bill in particular says businesses miss the message. Now cities and counties have to give out a notice to anyone applying for a business license or a permit that says you got to put up this sort of signage. And we got to be paying attention to this because it might apply to us, but also what comes next after they put you on blast, right? The penalties. So if you have clients or you have businesses that this impacts, make sure they have up the right signage. All right, crud, you're saying to yourself, right? More toilet talk. How many bathroom entries is this guy going to have today? Well, this is the last one. We're through the potty talk. You're saying to yourself, good, let's get back to professionalism. This one is interestingly enough tied into sort of what you're talking about at the end of the last session about diversity, equity, and inclusion. Now, there's lots of litigation on the other side, but our state is pushing full steam ahead. And you'll see 4, 5, maybe 6 entries today in our packet that deal with our state pushing forward on DEI initiatives. And this is one of them where essentially what they've said is, look, Cal OSHA by December 1, 2025, and now you're saying to yourself, that means we have to talk about toilets next year. I am not coming back. Not if this guy's speaking, right? If you're on a construction site, you're gonna have to have one single user toilet for anyone that identifies as female or non-binary. What they were saying was that businesses, at least in this sector, tend to have problems with DEI, and so they're trying to make some more movement in that regard. Okay, amends the Labor Code, Health and Safety Code. Now let's talk about retirement. And again, this is, you can see the bills there, SB 1234, which is what initially created CalSavers, and then the modification from a couple years back, 1126. This is number 8 in our packet, if you're following along. Now, most of you probably have your own retirement plan set up, but if you don't, and if you have 5 or more employees, right, you gotta have at least the CalSavers program. And if you're saying, well, what is CalSavers? You need to talk to a retirement specialist, or you can go online, Google CalSavers employer and read it. It doesn't require that you do anything other than set up the system. You don't have to contribute to it, right? You just have to get it set up, and you have to have something. As of 1/1/26, that requirement is going to drop down to 1 employee. Now, this doesn't apply to sole proprietors where they're the only employee of their own entity, right? That doesn't make any sense. Now, they probably already have individual retirement plans for tax purposes, but if they didn't, it wouldn't apply to them. But anybody else, you have 1 or more employees, you're going to have some sort of retirement plan set up. Now, I had a client say, well, I'm not doing that CalSavers thing. They're bankrupt. And I said, I don't think that's the case. Did a little research. It's not the case, at least not yet. So that's not going to fly. Make sure you got something set up. I'm routinely seeing handbooks where I still see something in there that has nothing about new retirement benefits, and they've got 5 or more employees. So a little note to yourself, if you don't have it, get something set up. Okay, food handler cards. This is one of these interesting bills that came up this year. We already know anyone in the food industry, you already have to have a food handler card. People that are handling food, they got to maintain it throughout their employment. There's a little bit of training that they have to do. They also have to pay a little bit of money to get that test done. So we want to make sure that people are having that. But what's interesting about this bill in particular, oops, I clicked off this for some reason, is that historically the people obtaining the card, they had to pay for it, and it was on their own time, on their own dime. Not anymore. This bill says that time spent by employees on the training and the testing is compensable hours worked. It also says you've got to relieve these employees of any duties while they're studying for and taking the test. It also says, and this is just down here, you can't require these people that already have a food handler card before they come into your business. And you got to cover the cost of the training. Now, the state is going to come up with, and I don't know why this takes a year, but clearly there's something more critical that I don't know about. But the state is going to, by next year, put up a website with other training options. Supposedly you can get it for less than 15 bucks. But the bottom line, if you're in the fast food industry or another industry where you have to have food handler cards, make sure you take note of AB 476, number 9 in our packet. Okay, COVID-19. We couldn't get through this program without talking about COVID-19. I really wish that we could. Frankly, if I could never talk about COVID-19 again, it would be the happiest day of my life. I would never talk about it. Never. Not ever. Not ever, ever. But we have to, so let's talk about it now. I'll just give you some of the really brief highlights here. It was effective this past February. It's going to stay in place, and these are the non-emergency standards. These replace the emergency temporary standards, the various iterations that we had throughout COVID-19 and the pandemic. These are the more permanent restrictions. 2 years are going to be in effect, 3 years for record keeping. Key takeaways for you: there's no more exclusion pay. Used to be that if somebody was exposed at work and they couldn't work because they had been exposed at work, you had to pay them for that time off. That doesn't exist anymore. We have more flexibility with your COVID prevention plan. If you're saying, what's a COVID prevention plan? We need to have a deeper conversation, right? But now it can be a separate document or part of your overall injury and illness prevention program, your IIPP. So you can put your CPP with your IPP and make sure you get it with your WVPP, which we'll talk about in just a little bit. That's a lot of PP, right? Now you're saying another potty joke, right? Gratuitous. Okay, Cal OSHA, we're gonna follow the California Department of Public Health in regard to isolation and quarantine standards. Go to the website. I have on my favorites list this website. Every time I get a COVID-19 question, I pull it up, I review the regulations because they change over time. Cal OSHA is gonna follow them. And note that if you have a local standard that's more strict, you got to follow that local standard. SLO, for example, has a different standard for healthcare industries. Outbreaks, you don't have to report to local health anymore, thank goodness. What's an outbreak? There's the definition if you need it. What's a major outbreak? These do have to get reported to Cal OSHA, not local health, 20 or more. Okay, and exposure notices, we're almost done with this, people. We're almost there. Supposedly, they're going to end at the end of this year, or unless extended. Leave for up to 15 days if you're doing the posting. Who does the posting apply to? Anybody that didn't have a close contact. Or if they are a close contact, they get an individualized notice. Again, until 1/1/24. So we're almost there. We've almost made it. Our last COVID-19 bill of the day, thank goodness, the right to recall. This is SB 723, and it really only does two things. So we'll go through this one relatively quickly. It's a very narrow bill, may not apply to you. It only does two things. One, it extends the date by a year. SB 93 would have expired at the end of this year, gives us an additional year of pain. Second, it expands the definition of who's a laid off employee. It says anybody after the Armageddon date, right? March 4th, 2020. We'll never forget that date. Presumption that if there was a RIF or some sort of layoff due to economic reasons, it was because of COVID-19. And the employer is going to bear the burden of rebutting that presumption. So that's the two main things that it does. It's very narrowly tailored. It only applies to airports, hospitality, building services, maintenance, event centers. And even within those designations, there's narrowing criteria. So it doesn't apply to everybody. If there's somebody that was laid off during that period since March 4, 2020, you're going to have to offer to rehire them to any position for which they're qualified, not just their former position, right? You're going to have to tell them within 5 days of the position opening, and then they have a certain period of time, 5 days, to accept. So in very broad terms, that's what SB 723 does. Okay, one more you probably never heard of. I do these programs live, and I literally ask everyone in the room, how many of you have ever participated in the CFRA pilot program by the CRD? And I have not to date had one hand go up, not a single one. But this is SB 756. The pilot program is for all small employers. This is our civil rights department saying, hey, look, if there's a CFRA claim or a bereavement leave claim, maybe this year, reproductive loss leave, we'll talk about that in a minute, then the CRD is going to send out a notice. If an employee goes to them and says, I have a claim, the CRD is going to send out a notice that says you can participate in mediation. Instead of going right into the enforcement arm and filing a response, you can go to early mediation. This bill, all it does is extend it by a year. Maybe they're hoping to find that one employer, right, who's gonna participate in the program. Anyway, that's all that bill does. Diversity, equity, and inclusion. This is another one of our state trend bills. This is SB 477, not necessarily an employment bill, but what it does, it provides funding from our state tax dollars to create a nationally aired, nonpartisan marketing campaign about social equity, civil rights, anti-discrimination. So very interesting how that's going to play with what we heard later in the federal cases that are coming out. It also takes away the 7-year-old travel ban that said these state workers can't go to any state that has discriminatory laws using taxpayer funds. So now we got to pay for a taxpayer initiative, right? Nationally aired program, and we got to send people to these states. So I'm just seeing my tax bill going up, right? Ryan, never going to retire at this point. I like the intention. I don't like paying more taxes. DEI is a critical initiative. And so the takeaway for you is review your policies and procedures. And while I'm not saying you should institute, diversity plans like they were talking about earlier, what I am saying is review your policies. If you see gender specific terms, for example, he, she, change those to you or your, right? Change those to employer or employee. Be a little bit of a forward-thinking employer, see the trend in advance, and make sure you're doing that. I can't tell you how many handbooks I go through, they're still talking about gender-specific terms. Even dress codes, where they're saying men wear this and women wear that, right? We need to get with the times. Electronic notification of benefits, this is AB 1355. If you're in our packet, it's number 15. And all this one says, in essence, is that through January 2029, and it's likely to be extended, this is a trial run, that employees can opt in to receive certain benefits via email or some electronic notification. These are tax documents, California federal earned income tax credit, your unemployment documents. If they don't do that in the former rule, the standard rule is you got to give it to them via hand or via mail. But now if they opt in, we can use this newfangled thing called the internet. Our state is slowly catching up. Okay, fast food, out with the old, in with the new. First, I'm going to give you a little recap. This is number 16. This applies to the fast food industry, but it has much broader implications. So don't fall asleep here. If you're not in fast food, you're saying this doesn't apply to me. It does, and I'll tell you why in just a second. But this goes into a buildup from last year, right? The FAST Act, you'll remember this. What it did, it created a fast food council, and that council was going to be able to establish industry-wide rules for wages and working conditions. We call this sectoral bargaining. Unique, first of its kind bill. Would have created a $22 an hour minimum wage. There was a bunch of political maneuvering, right? The fast food industry didn't like it. They have a pretty strong lobby. They started pushing back pretty hard. In fact, the day after the governor signs AB 257 into law, they start the process of qualifying a referendum to go on our 2024 ballot, and they get it there. And that stalls out the FAST Act implementation. Now, our state didn't like that, and the labor union didn't like that, so they pushed back. Our state then refunds this past year our Industrial Welfare Commission. Now, for those of you who don't know, the Industrial Welfare Commission, there's 17 wage orders. There's one that applies to every single one of your businesses. I'll give you a good example. Manufacturing's wage order 1. Agriculture might be several. Could be 13, 14, could be 8, 4. My office, right, white collar law office, wage order 4. And there's a number of these wage orders, but one applies to everyone. Well, they refunded this Industrial Welfare Commission that's been dormant since 2002. They gave them $3 million. They also created a bill, AB 1228, in a different format that said we're going to make joint liability for franchisors and franchisees. Well, they hated that. So then the governor steps in, his office, they start doing some negotiation. September this year, they come to a compromise, and that's what we're dealing with today. This new bill, this compromise bill. So what does it do? Here's the changes. It says the FCC is now only advisory in nature, except for minimum wages. They can set minimum wages. For everything else, if they want to develop a workplace standard, they got to go through one of these administrative agencies. And that agency has to promulgate the rules through the normal rulemaking processes. And that can take a while. The composition of the FCC, the council got fairer. Before it was heavily weighted to the fast food employees. Now it is broken out equally between the fast food employees and the fast food employers. And there's somebody who's unaffiliated with both who chairs the group. IWC defunded, thank goodness. Joint liability bill quashed. Minimum wage adjusted downward from 22 to 20. And the FAST Act, the referendum is coming off the 2024 ballot. So that's what we did. So what does this bill do in particular? Let's talk about it. We get a new minimum wage, $20 an hour, effective April 1, 2024. I'll tell you in a minute just who it applies to, but think about this. I told you there's broader tie-ins. If I can go work for $16 an hour, which is going to be the new state minimum wage come January, or maybe there's a local or a slightly higher minimum wage, but it's not $20 an hour, or I can go work at McDonald's for 20 bucks an hour. Am I going to vote with my feet? Think about the upward pressure that this is going to cause on all minimum wages over time. It's also a trend where our legislature has created an industry-specific bill, an industry-specific minimum wage. It has broader impacts. There's going to be increases over time, right? And we're going to hear about later another industry-specific for healthcare minimum wage rule. So this is a coming trend, something to be aware of. Salary for management, because it's a state rule, state minimum wage, $83,200 is going to be the base minimum salary for an exempt employee in the fast food industry if you're covered by it. Local minimum rules, you can have them so long as they're higher than this current $20 an hour rate. So what does it do? Who does it apply to? If you have 60 more establishments nationwide, you have common branding, you do food and beverage service for immediate consumption on or off the site. So think about your Taco Bells, right? Your McDonald's, your Wendy's, these sort of establishments, Starbucks, right? These are who it applies to. Used to be 100 under AB 257, so they lowered that number. If you're in that NAICS code, this bill probably applies to you. So just double check that. Doesn't mean it does, but it's a good indicator. It excludes bakeries, people that make bread on site, and restaurants inside of grocery stores. So think about your Starbucks and your Ralph's, for example, right? FCC, it's going to sunset on January 1, 2029, unless it's extended. So again, my feeling here is that this is really going to impact much more broadly than just the minimum wage for workers. I have clients telling me right now, number one, in the fast food industry, they don't know how they're going to take this increase and funnel that down to the clients. There's no way, right? They can move $4 an hour onto the client, right? There goes the dollar menu, right? Now we got a $10 menu. This is a real problem, right? $15 an hour, $15 cheeseburger or whatever it is. But the bottom line is this is going to create a lot of pressure statewide on the minimum wage. And again, I think it's going to create upward forces and impact even employers who say, I'm not in this industry. Okay, let's talk about weed. We're just talking about food, feeling a little hungry. Let's talk about weed, right? Got the munchies. So this is AB 2188. This is a reminder. This is from last year, number 17 in our packet, if you're following along. Remember that this bill, and interestingly enough, we weren't the vanguard on this. There were 7 states ahead of California, right? You know, somebody at the legislature got fired for missing that one. How in the world did you miss that, is what our legislature said. But at its most basic, it goes into effect January 1. It says that it's a FEHA, a Fair Employment Housing Act discrimination violation to discriminate, harass, retaliate against somebody based on their off-duty, off-site use of cannabis. So it's a serious deal. And you got to update your handbook accordingly. We'll talk about that in a second. Essentially, it says now you can no longer test for metabolites. Now, I am not a weed expert. I am not a testing expert. I'm just playing one today here. But my understanding that THC is the active ingredient that causes impairment. The metabolites are what happen after your body breaks down that THC when somebody's no longer impaired. And those can stay in your system depending on the test used for 30, 60, 90 days, a long period of time. But what the law is now saying is we want to focus on impairment. And we're going to treat weed more like we treat alcohol, meaning we don't want somebody at work impaired in the moment, creating a safety risk. So you're going to have to change your testing appropriately. The other prohibitions, people still can't have it on site. They can't use it on site, right? They can't be impaired while at work. They can't go smoke and then come back from lunch impaired, right? All of those are still protections that exist for employers. There are exemptions. I get this question all the time. Who is exempted from this bill? Well, employees in the building and construction trade. It doesn't say applicants, it says employees. Some government agencies, right? If you're DOT regulated, if you're regulated by the FAA, or right, we're thinking pilots, etc. These sorts of businesses are excluded. Other businesses that receive federal funding, so federal contractors, and the federal government is requiring you to do the testing, you're excluded from AB 2188. But for everybody else, which is almost everybody, you all have a drug use and abuse policy in your handbook. Make sure you've updated it before January 1, 2028, right? Make sure you're compliant with AB 2188. And some of these exclusions only apply to certain sectors of your business. So we need to be thinking about that as well. One more on weed. Don't even ask about it, I say. This is SB 700. It's a companion bill to AB 2188 that essentially says employers cannot ask about prior use of cannabis. Some employers were getting creative and said, I'm not going to test for it. That's going to be a FEHA violation. I don't want to have to deal with the risk. So I'm just going to ask people, do you smoke? And if they say yes, you're out. Well, now they say you can't ask about prior cannabis use. It's unlawful. They also say you can't ask about criminal history, information about cannabis. And employers, if you're required to do it, again, there's an exclusion for you. I've given you sort of the example here. But note that there is no exclusion for the building and construction trades on this one, unlike AB 2188. I have to apologize a little bit for my voice if it sounds scratchy. I woke up yesterday with a little bit of a cold. So I wake up this morning and I say to my wife, man, my throat's feeling rough. My wife says, here, have some honey. It was lemon and honey. She said, make this thing for me. Okay, fine. She hands it to me. I drink it and I scald my throat. So now I've got a scratchy throat and it's burned. So I apologize in advance if I sound a little bit scratchy, but that's what I'm dealing with today. But that's the basics on weed. Okay, identity, affirmed use. Again, two more. It looks into what our state is doing so that you can focus on what are you doing as an employer. We have AB 760, state universities. They now have to use the gender affirmed name. It's required by law for them. SB 372 says the DMV is going to have to update licenses and registration. So again, think about the trend, right? All ties back to your workplace. What are you doing? And make sure you're dealing with counsel of record to make sure any initiatives that you have are compliant. New I-9 form, number 20 in our handbook. This is live today, right? It was live as of a month ago. So all of us need to make sure we're using the right form. How do you do that, Ryan? You say to me. Well, look at the bottom left-hand corner of your form. If you see that date, then you know you're in the right form. If you don't see that date, then you're not in the right form. Make sure you get with the right form. Some minor revisions. Really what they did, they consolidated section 1 and section 2 into one page. They added some separate supplements. But the bigger picture issue is they added a checkbox allowing for remote verification if and only if you're an E-Verify user. So if you do E-Verify, you can remotely verify the I-9 documentation of your workers. For everybody else, you still got to do the age-old in-person verification. We don't have the COVID flexibilities anymore. Those went away in the end of the summer. And by August 30, you all had to go back and re-verify all the people you remotely verified during COVID-19, except for E-Verify users. Now, I get this question all the time. Well, how am I supposed to go track down these people and do it myself? This is from the UCSIS website. It says you may designate an authorized representative to fill out the I-9 on behalf of your company, including personnel officers, foremen, agents, or notary publics. The Department of Homeland Security does not require an authorized representative to have a specific agreement or other documentation. Okay, pretty straightforward. Just make sure you have the right form. Make sure, and generally, you're at this time of year, make sure your new hire packet is up to date. I was just dealing with one today. In case you didn't know, the SDI brochure, which has been the same forever, has been updated. So make sure you're looking at your new hire forms for the new year. Get the correct links in there, get the correct documents in there. Independent contractors, don't do it. The law hates them, right? This was the biggest initiative for the federal and state government before COVID-19. They're going to get back to it. But that's not what this one says. This bill says there's a couple exclusions. I'm just going to plug these up. Manicurists, construction subcontractor, newspaper, and if you're a commercial fisher on an American vessel, you can still use the former test for independent contractors, the Borello test, and not the current ABC test. Everyone else, we're going through the ABC test. Now there's a couple other exemptions. AB 2257, but that was a different year and a different topic. Okay, reproductive loss leave, one of our big bills of the day, SB 848, number 22 in our packet. Let's talk about it. What is it? Well, it largely tracks last year's bereavement leave. And people say, Ryan, is this a new leave law? And I say, I don't think it is. What it is, for me at least, is another form of bereavement leave for somebody who has suffered a reproductive loss leave event. Now, certainly, if there's a pregnant employee, they might be subject to different rules, PDL, right? FMLA, CFRA, possibly, depending on the scenario that's coming up. This is different than that and broader than that. This is for anybody that could be presumed to be a parent of the child, fathers, right? Domestic partners, registered domestic partners. These sorts of individuals who have suffered a reproductive loss leave event. It applies to companies that have 5 or more employees and all public employers. They still, just like bereavement leave, have to be working for you for 30 days to become eligible. A reproductive loss leave event, an RLE, is defined as these things: miscarriage, stillbirth, failed surrogacy, unsuccessful assisted reproduction. I was a little bit shocked by this, but a failed adoption. If those come up, there's an RLE event, they can take up to 5 days of unpaid leave to go out, right? And I say it's bereavement leave here, but it's reproductive loss leave, which is, to me, is a form of bereavement leave. You can use PTO, vacation, sick leave benefits to cover the unpaid time off. Employers could choose to have a paid policy. Again, this all tracks the bereavement leave bill from last year, which was SB or AB 1949. I can't remember. Why? How is it different? So you can flag the slide and you can put down, Ryan says these are the differences. Well, just like bereavement leave, reproductive loss leave doesn't have to be taken consecutively, but it has to be completed within 3 months unless there's another statutory leave law in play. In those instances, then the reproductive loss leave has to be completed within the 3 months afterwards of the other leave. So if they take a PDL and they complete PDL, the reproductive loss leave has to be completed within 3 months after that end date. There's not unlimited RLE, right? This is unlike bereavement leave where grandma could die 10 times. I got to go to grandma's funeral 10 times this year. Unlimited events. This has a limit of 20 days in a 12-month period if there's multiple RLE events. You can't request documentation for the underlying incident. That's different than bereavement leave where we can ask for the documentation, right? Show me a picture of the body in the casket. Don't do that. Some other form of documentation. Any information you get is kept confidential, but the key takeaway, again, update your handbook. You have 5 or more employees. You need a new section in your leave loss section that talks about reproductive loss leave. So add this to your takeaway action item list. Local law enforcement. This is SB 594. This was a fun one for me. I looked at this and I said, what is this? Essentially, in our budget bill, there was $18 million that was earmarked for local law enforcement of labor code claims. Then we got this bill that said DAs, district attorneys, can now apply to grant funding from the state to criminally and civilly prosecute labor code violations. Apparently, our DLSC, their Bureau of Field Enforcement, the Department of Industrial Relations generally doesn't have enough funding and they don't have enough people. So what they said is, we're going to deputize the district attorneys to go out and enforce the labor code for the first time. And you're saying, is this happening? Well, San Francisco already has this set up. LA already has this set up. In fact, LA has 4 dedicated district attorneys. They call them the Workforce Justice Unit that's set out to prosecute civilly and criminally labor code violations. I've never seen in all my years a criminal prosecution of a labor code claim. I'm sure it's happened, but I haven't seen it personally. That could be changing now in the future. Big cities are already doing it like I talked about. They can't do PAGA claims. They can't do ag labor claims. And here's a big one. You cannot force them into arbitration. Just like we can't force the labor commissioner to go into arbitration, we can't force claims brought by the DAs into arbitration. Okay, local rules, some more things. Check your local rules. They abound, they're everywhere, right? We're getting more and more by the day, it seems like. We have this piecemeal legislation all over. I'm just going to plug up a couple here. We're not going to go through these in any detail at all. But what I want to give you is an example. This is not an exhaustive list by any stretch of the imagination. You can read these on your own. But what I want to say is if you're in an area Remember, federal, state, local, and administrative rules all apply to you. So make sure you're checking out your local rules. Meal and rest periods for cabin crews. I'm just going to plug this up. We'll blow through this one quickly. Probably doesn't apply to any of you, but if you have a cabin crew worker who's covered by the Railroad Act and a valid CBA, then the meal and rest period rules don't apply to them. They get their own rules. By the way, this was one of the urgency bills we talked about earlier. No idea why this was urgent. Maybe they were working on the governor's plane. I have no idea. But this was one of the urgency measures he signed. Non-competes, this is a huge bill. And so is the next one that comes up next, AB 1066, right? It's declaratory of our California Supreme Court decision in Edwards versus Arthur Anderson that essentially said non-competes are void in California. I have this conversation with clients at least 4 times a week. Somebody calls me up, says, somebody left, they went to a direct competitor, they signed a non-compete, how do I enforce it? And I have to tell them, tough noogies, right? You're out of luck. But this bill, what it says is, we're going to apply these non-competition provisions of that case above to non-contracting parties. I don't really know what that means, but I'm thinking business to business contracts. If they can somehow show that a invalid non-compete somehow impacts their operations, they might be able to use it. But here's the bigger piece. If you have non-competes or you've had a non-compete in your contract in California since the date that's on there, 1/1/2022, then you're going to have to give notice to those employees in writing, individual notice, agreements void. Has to be sent by Valentine's Day. Happy Valentine's Day to you. We're also smiling and happy and feeling warm and loving, right? So last known address and email address. Oh, and by the way, now if you put an invalid non-compete into your agreement, that is unfair competition by law under the Business and Professions Code, and somebody can sue you for it. That takes us to SB 699, number 28 in our packet. Again, expanding the prohibitions against non-competes. And this one's going to be very interesting. This was the Edwards versus Arthur Anderson holding I told you about before, and you can see how broad it is, right? Restrains every contract. There's very, very narrow exceptions tied to the sale of business. But again, very narrow provisions laid out in the Business and Profession Code. This bill in particular does 4 things. It says a non-compete is void and unenforceable no matter where it is entered. So if somebody in Florida enters into a valid non-compete under Florida law, but then they come to California and a California company says, I want to enforce this valid Florida non-compete, or the Florida company says it, California courts are going to say, no way, no how. We don't enforce those here, right? Current and former employees can't enforce non-competes regardless of where they're signed or when they're signed, right? Even if they're maintained outside California. California is a no non-compete state, barring those very narrow exceptions. Employers entering into these agreements, they're unenforceable, they're unlawful, and now it's a civil penalty, and they can collect attorney fees against you, right? These people have a private right of action to come after you. So you got to get rid of it, and allows a prevailing attorney to collect their attorney fees and costs. Big win for the bloodsuckers, right? For the attorneys, all of us out there litigating these things. Bad news for all business. I think there's constitutional issues here. I'm expecting challenges by other states against our state. Typically, the federal constitution says that one state cannot reach into or impact other states' operations, right? This is the Dormant Commerce Clause, but we'll have to see what happens there in general. Okay, one more takeaway. Make sure you've updated your agreements, right? You heard earlier about the Stericycle case. I won't talk about the day, you'll hear about it later during the case law update. But that case has huge impacts on what's allowable or not. Again, with these rules, make sure you've updated your confidentiality agreements, your non-disclosure agreements. And while we're talking about that, remember this federal bill from last year. This is from December 2022, the very end of last year. Continuing of the Me Too movement said, you can't have blanket non-disclosure agreements about pre-dispute sexual assault or harassment claims. So we can't quell speech before it's occurred. And then it's all, again, flowing out of the Me Too movement. We want to empower these victims to come forward and tell their stories. And so we're getting rid of it. Okay, there's the definitions. You can look back at this later if you want the definitions. Outdoor heat illness regulations. You'll remember a couple years ago, 2016, we had outdoor heat illness. Now we're getting indoor heat illness. These indoor heat illness rules have been in place since 2016, but every OSHA expert I talk to says they're coming. They expect it in the fall or before the summer next year at a minimum. So you can prepare. Here's the basics. If you have an indoor place of business that gets over 82 degrees Fahrenheit, you got to have some special protections for heat illness. This should be part of your heat illness prevention plan. That goes with your IIPP. Okay, greater protections in high heat scenarios. Like I say, you got to have a heat illness prevention plan. Outdoor heat illness already has to have this. Maintain cool down areas while employees are present. You have to allow them and encourage them to take these 5-minute rest breaks whenever they feel the need to do so. You have to have access to fresh, pure, cool, potable drinking water. So you can't say to an employee, for instance, boy, you look parched, right? Give me some cash and here's some water. Can't do that. Provide first aid and emergency response if you have to do it. Employers have to train on this stuff. So in the past, we've had these injury and illness prevention plans, or most employers, some employers don't even have one, but nobody's trained on it. We're seeing a lot of emphasis and push on training on all these pieces of your IIPP. Another one, and we'll talk about the Workplace Violence Prevention Plan, the WVPP. Again, another part of your IIPP. But first, let's talk about TROs. This is SB 553 and SB 428. We'll talk about them together. They both go into effect January 1, 2025. And essentially what they say is employers and union reps are going to have easier access to the court system to bring a TRO, a temporary restraining order, against somebody outside the business harassing employees in the business. Right now, it's a very high standard. It's hard to do, but the bottom line is the courts, it's going to make it easier coming up here pretty quick. We have to have an individual illness and workplace prevention plan, part of your IIPP or a separate document. So we'll just plug these up out restraining orders because we want to get to what everyone wants to know. The WVPP, who does it apply to? Everyone. If you have one or more employees, there's a couple exemptions. Healthcare facilities, you already have these. Department of Corrections, everyone gets that. Certain law enforcement. Where it applies to any place of employment, employer provided housing, and to employees. It does not apply to remote workplaces. So you're not going to have to go in and make a WVPP for all of your remote workers. Also doesn't apply to any workplace that has 10 or fewer employees. When? By July 1. What has to be in it? You've got to maintain and implement an effective WVPP. I'm glad they use the word effective, not ineffective, right? Critical drafting right there. What goes in the plan? Well, a lot of stuff. Who's responsible, right? Effective, again, that word. How do you respond? How do you report, right? How do you deal with it? How do we communicate to employees when this happens? Now, this all flows out of these workplace violence incidents we've been seeing, whether it's at workplaces or it's other places that have become more prolific over the years. Unfortunately, in my neck of the woods, we just had one of these recently in the last couple of years. It was really traumatic. Effective response to procedures. How do we deal with this stuff? And many, many other items. You're going to need to get this in place, but don't fret. Here's my expectation. Cal OSHA, just like it did with the CPP, the COVID Prevention Plan, and just like it's done with your IIPP, they're going to put out a model form. And my expectation, they'll put that out before July 1, 2024. So be on the lookout for that. You got to provide and review and revise it annually. And anytime you revise it, you've got to train on it. So you have to train when you initially give it out, and think about who's going to do this. Who in your workplace is qualified to do workplace violence prevention training? Are you going to call in the sheriffs or some law enforcement agency? They have these arms that will come out and do training at your site. You're going to hire a consultant. Is this going to be sort of like your annual or biannual harassment prevention training? We're going to have to do these sorts of trainings. You got to keep records. Like all Cal OSHA stuff, most of it has to be kept for 5 years, but the training records only for a year. But this is very complex. So make sure you're paying attention to it. And by July of next year, really be watching to make sure you have the WVPP ready to go. Okay, takeaway, again, watch for the model. Ballot measure, I just want to scream this out as loud as I can. Get out and vote in particular for this ballot measure to repeal PAGA, the Private Attorney General's Act. You're going to hear about this later. I'm sure the speaker will scream out loud, PAGA, and he'll say lots of things. We got to get rid of PAGA. This is one of the things, this is actually a ballot measure to repeal it, would say, hey, we're going to get rid of PAGA, totally out of control. Instead, we're going to better fund our labor commission. And only our labor commission should be able to bring civil penalties against employers. I would sing praise. All I want for Christmas is PAGA repeal, right? So if you're thinking about a present you wanted to get me PAGA repeal, get out and vote. Okay. Paid sick leave, the big one of the day. Everyone wants to talk about paid sick leave. Really, it only does three things. Everyone's freaking out a little bit, right? We're still waiting on our Labor Commission to give us some updates. I just went to their frequently asked pages on sick leave right before this, and it's still the update from March 2017. So not particularly helpful, but I'm assuming before year end, we're going to get some updates from our Labor Commission. They're going to tell us a lot more about how they're going to interpret these changes. Well, it does three things. Increases the hours and days of paid sick leave and the way in which it's given in certain instances. It expands protections for certain union employees, not construction union workers, and it excludes railroad workers. I'm assuming we don't have any railroad workers, so we'll probably skip over that. Defines full amount of leave. Instead of being 24 hours or 3 days, it's now 40 hours or 5 days. That's the minimum. Applies to these workers as well. The standard accrual, you can still do it. 1 hour of sick leave for every 30 hours worked, but they can use 40 hours or 5 days in any year. It used to be 24 or 3, right? So that's gone up. This is a question I get all the time. Under this normal standard accrual method, in the first year, do people by the 120th day have to have X amount of time on the books? By the 200th day, they have to have 40 hours on the books. The question is unanswered right now. We're waiting for the Labor Commission to give us the answer. The question is not unanswered if you use an alternative rate, which is something other than 1 for 30. If you use something other than the standard accrual rate in bullet 1, then by day 24 or by day 120, these are calendar days, you got to have 24 hours on the books. By day 200, 40 hours on the books. That's not questionable. If you do front loading, there's no carryover requirement, but now you got to give at least 40 hours or 5 days. PTO, you can still do it so long as that plan meets the paid sick leave and vacation, I put these out there, carryover accrual use requirements in California. Grandfather plans, if it applies to you, read this bullet. We just don't have enough time. Partial preemption, one of the big pushes with this bill was, hey man, we got all these piecemeal legislation across many localities, about 8 of them. We want to get rid of that. And so the state said, yeah, well, we're not going to give you what you want, but we'll give you a partial preemption. I'm just going to plug these up. You can read about them. But the point of it is, other than those 6 things I put on the screen for you right there, those are the only things that state rules will preempt as far as local rules. So that means if your local area has higher accrual amounts, carryover requirements, different rules on how things accrue, you got to follow the local rule. Okay, union employees, we get some extra protections, not construction, but everybody else gets some protections, anti-retaliation rules. We can't force you to get a replacement when you're sick, and we're excluding railroad workers. This is another, and check your local rules, please, please, please. If you're in San Diego, Los Angeles City, West Hollywood, Santa Monica, Berkeley, Oakland, Emeryville, or San Francisco, you have specific local rules that apply to you. And those are in the city limits. So make sure you're paying attention. Takeaway, update your handbook. Every handbook I see needs to be updated in this regard in some form. And we're also going to add in there that they can use sick leave for reproductive loss leave. Okay, higher rates here. I'm just going to plug this up. Essentially, we got a bill from a couple years ago, and this is just going into effect now. We're going to phase in increased SDI and PFL rates for the lowest income earners. There's going to be no cap on your wages, and this is where it's going to impact some people here. There used to be a cap on how much they would tax, right? Once you hit this cap, no more taxes came out of your money. That is gone as of the end of this year. So again, more taxes for Ryan. Ryan is never going to retire. And this is just the reality of the situation. But this is to get more benefits to lower income workers when they're out for covered leaves. Pregnancy laws, I'm just going to plug these up. We have the pregnancy, the PFWA, right? This is a federal law, talks about pregnancy accommodation. The companion bill was the PUMP Act dealing with lactation accommodation. I've given you the effective dates for both of them. For California employers, you have already lactation rules. You have already the PDL. And in most instances, it's much broader than these protections. So we're using California rules. Okay. Oh, one other point. If you want to take a look at this, this is really good reading just on reasonable accommodation generally. Look at the EEOC guidance on the pregnancy accommodation requirements. EEOC, type in EEOC, PWFA, FAQs. Take you right there. Great reading. CCPA compliance. Make sure you're following along. I only want to talk about this in one sense. Number one, does it apply to you? This is And you can see up there, the California Consumer Privacy Protection Act. But it went into effect in 2020. There was exclusion for employment-related records until January 1 of this past year. Those are gone. So now you need to know, does this apply to you and what do I have to do if it does? It applies to you if you're a for-profit California business and you meet any of the three criteria right here, any of them, not all of them, any single one. Most of you probably would hit prong 1, if any of them. If it does apply to you, remember, there's also, you can't say, hey, look, there's multiple entities here. I'm just going to pick this one. We don't apply, none of that applies. If there's joint businesses, it's going to apply to you. If you voluntarily say you comply with it, it's going to apply to you. Where does this come up for HR professionals? Hey, how about delete my file request? The CCPA and the CPRA, which is the amendment, define consumer very broadly, and it would capture employee and employee documents. So if an employee comes to you and says, I need you to delete my personnel file, I really don't like that last performance review. I'd like to get rid of that PIP. That really doesn't make me look good. You can say, I have a duty under the labor code to maintain these, right? We have labor code 226, 1198.5, right? 432. These labor code sections require us to keep employment related documents. And so we got to do that. But work with your counsel of record, because it may be that you can deny the request as to some documents that are mandated to maintain, and you may have to delete other documents. So work with your counsel of record. Okay, update your handbook, your notices. There's new hire notices. There's website compliance. So put down a little takeaway. If this applies to you, you need to talk to a specialist, a CCPA specialist. Okay, privacy, reproductive. Essentially what this does is it says, we got all these digital apps out there collecting all kinds of information about people. Highly sensitive information, menstrual cycles, reproductive cycles. Are employers using this sort of data to see who's pregnant or likely to become pregnant? There was no protections for them. This bill in particular, AB 254, number 37 in our packet, slides them into covered medical protections in California. Privileged communications, AB 933. This is an amendment to Civil Code Section 44. It expands that qualified privileged communication to say, even so long as somebody makes a statement without malice, even if there's no formal complaint filed about sexual harassment, assault, discrimination, that it is a qualified protected communication. There was a horrific case in which somebody was sued for alleging that a state senator had sexually assaulted them. They then got sued for defamation and a number of other things. And so this bill in particular creates a qualified privilege in the law to make statements about sexual assault, harassment, and discrimination, even if you haven't filed a formal complaint. Okay. Protected category FEHA expansions. This is a reminder from last year. If you didn't do it already, make sure in your laundry list of EEOC categories, it takes up a full page in your handbook at this point. Oh, we gotta be done real quick. Add it to your list, make sure it's in there. Okay, public sector employer, joint several liability bill. How much time we got before we get really squeezed here?
All right, we do have some questions, so I want to make sure we have at least 5
okay.
minutes left over. We'll do
Yeah.
rapid fire on the questions.
Okay. All right, 5 minutes. We'll get through these all in 5 minutes. We only got a couple more to go. So joint several liability for public employers if they do property, service, or long-term care. That's what this says. If it applies to you, check it out. Retaliation. This one's a big deal. It says there's a rebuttable presumption of retaliation if you fire somebody within 90 days of them engaging in protected activity. Big deal. They complain about their wages, hours, working conditions, they get terminated. Rebuttable presumption in the law, it's retaliation. What I want to flag for you is this is not a free pass on day 91. Don't say, I'm just going to wait until day 91 and then fire them. It's retaliation day 91, 92, 95, if you're doing it for the wrong reasons. Again, you can rebut this presumption, but the burden's going to be on you as the employer. Huge penalties, as you can see. Safety in the motion pictures. We all heard about the Rust incident with Alec Baldwin. There's now some funding and tax credits that are available for the motion picture industry if it applies. Schools cultural competency training. I'm just going to plug this one up. The state is going to mandate that teachers do cultural competency training. Again, the DEI push here. Smoking, don't smoke in hotels. We're getting rid of that thing that says 20% of the rooms can be smoking. Finally, they're all non-smoking now. Secret ballot. This is another urgency measure. This is ag sector only. 2 ways to do the vote. We heard a little bit about this earlier in general union terms. In ag, they can either do it by secret ballot, which is the normal way to do it, or this majority support petition. My materials have all kinds of information about this if it applies to you. Vetoed bills, these are all coming back. I don't want you to ignore this slide, although this is my favorite slide of the whole presentation, right? The bills we didn't get. Pay attention to these because they're coming back in some iteration here. Minimum wage hike, we're going up to $16 an hour. We got to do it. Remember the ripple effect it's going to have on your exempt employees. I put the numbers up there for you. Remember to check your local rules. We got over 40 areas with local minimum wages higher than our state minimum wage. And we got a November ballot measure. And again, get out and vote against it. Raise the minimum wage to $18 an hour. Federal increases, just going to plug those up, right? You can see them. Federal law is going up. This doesn't impact us in California because, and we don't care, we're higher, right? And you always follow the higher law. Wage increases for computer software and physicians. They have very special rules. You can actually pay them hourly so long as they get enough, and they can be excluded from overtime. I don't see this come up very often, so we'll move forward. This is the last big bill I want to talk to you about. I told you there was a healthcare bill that said we're going to do a specific minimum wage for healthcare. This is a phase in over time. We're going to feather it in over a number of years until we get to $25 an hour for covered individuals. That's going to impact as well these exempt employees. They have a different standard than the state standard. So take a look at bullet 2. It's the higher of 1.5 times the healthcare minimum wage or 2 times the state minimum wage. There's going to be increases, right? CPI index increases, and local areas are entirely preempted from establishing rules unless they put something in higher than what the state is requiring. So again, the upward pressure we're going to see on minimum wages. Bill, we'll leave it there for now. I want to make sure we get to some questions that we have, but that's all.
Terrific. Thanks so much, Ryan, for absolutely amazing presentation and just the amount that you got through in what we thought was a generous amount of time, but we realize now we always need more time. So thank you for that. Just a couple of areas that seem to stand out a little bit more on the questions.
Sure.
First of all, with the new leave requirement for reproductive loss, you are still suggesting this should be separate policies, right, in our handbooks. Bereavement separate from reproductive loss leave, correct?
That's correct. I have them as separate policies in the handbooks I draft. It's a different bill. There'd be too many differences between the two to leave them as one.
And in the unlikely event that somebody has a married couple or two that would qualify under a leave for the same thing, are they both? I know this comes up with FMLA sometimes. Are they both entitled to the same leave? Or are there any restrictions on that?
The bill doesn't actually specify that, and it doesn't say. Certainly with CFRA, right, there's specific requirements about what they can and can't do in that scenario. So I'm assuming we're going to get additional regulation on that, or somebody's going to litigate it, and it's going to come up. But I would assume that both parents would be able to take the reproductive loss leave at some point.
And also to clarify, I know this is a tricky one, right? A lot of numbers that come up here. But in the bereavement, we have 5 days, 5 unpaid days per event. Under the reproductive loss, we have 5 days, a little bit more limited. Does that mean are they consecutive or simultaneous? In other words, can I take 10 days unpaid for a single event?
And then reproductive loss leave for the same event?
Yeah, for the same event.
No, it would be one or the other. The legislature's clearly carved out a specific category for this, so it would be one or the other.
Excellent. And then the other area we got some questions on the workplace violence prevention plan. How does that, and I know that there's still a lot to be decided on that. And we do have a speaker from Cal OSHA later in the day who will be addressing some of this as well, but also will be saying, hey, we don't know all this stuff yet. We haven't decided. Remote workers, how are they impacted by this? Do we know that yet?
Yeah, so it said as one of the specific carve-out exemptions was for remote workers, meaning that they aren't subject to your workplace violence prevention plan, right? We're not going to have to protect their home from active shooter events.
Right? Okay, excellent. One paid sick leave related question too. Do we know yet? Have we seen, because we have to make a change, right? If we front load and it's not calendar year, if it's based on something besides the calendar year, have we been given the guidance yet as to how we're going to make that adjustment in 2024?
We have not gotten the guidance yet. So again, what I have on my registered to-do list every day when I come in, I type into Google DLSE FAQs sick leave. and I pull it up and I look for the date on the top, which says March, whatever, 29th, 2017. If I see that, I just skip it. We don't have that guidance yet. So I'm telling employers, if you want to be most conservative, bump again, this will be like the first year of front loading anywhere where it's always a little bit wonky. Front load everybody back up to 40, right, wherever they're at, and then just go back to your anniversary year after that.
Yeah, it's going to be a tricky one, and I think we're all fighting for that bandwidth on the website there, checking those for those FAQs. Last question, and this is one that has come up at previous WeLose, and we've asked your colleagues about this in the past, so thought taking advantage to ask you. Arbitration handbooks. What can you advise us? Number one, in terms of the relationship between our arbitration policies and the handbook, and kind of hinted a little bit about this already, but when we need to either develop an arbitration agreement or update our arbitration agreement, what should we do? How should we go about doing that, and plug away on that too? That's kind of an opportunity.
I love arbitration. We win cases in arbitration that I'm absolutely certain we'd lose in front of a layperson jury, because we just can't argue the level of nuanced law to a layperson jury that we can argue to a judge or a jury, or argue to a judge or an arbitrator, who's usually a very experienced employment attorney, if not a retired judge. So we win these cases all the time in arbitration. We think we might lose or get a bad result in front of a jury. So number one, we love arbitration. We do it with our employees in our office. So if you think we're plugging something we don't do, we do. I want to keep it separate from the handbook as a standalone agreement that they sign. You should have a policy in your handbook that says arbitration. You should have something in your application that says we do mandatory arbitration. With the offer letter that you give people, you should give people, right, your arbitration agreement, make it a contingency of hire. Right? You have to sign this when you return our offer letter. I love to have it as a separate standalone agreement. Like you said, I want to have people sign the new one whenever it comes out. Now, you can give that out along with the handbook changes. And my clients in general, every time there's an update, we have them roll out a new arbitration agreement and keep each version of the agreement that's signed. We never know where arbitration law is going to end. So you have multiple agreements that they've signed over the years. It tells you, number one, they were aware of it. It wasn't a surprise. They knew about that agreement. They signed it multiple times, and you have various iterations of it, one of which is going to be enforceable. I don't know if that answers.
Absolutely awesome. Yeah, and that is a question that comes up a lot, and really appreciate you reinforcing that, and very much in line with your colleagues, with your guidance on that. So thank you for that, and thank you so much, Ryan, for everything. I mean, I really feel that we really got through an awful lot. We were able to address pretty much all of the questions that came up. So thank you so much again for that. For everybody in attendance, one thing I'd like to point out, Ryan, too, that I'm really impressed with is I'm looking at the list of people who are here, and I'm seeing a lot of people who saw you last time and are back again today for more. So that's always a really good sign that we just can't get enough.
Yeah.